everyone, and welcome to this month's Estate Stewards webinar. Thanks for taking the time to be with us here today. We're very excited to have Michele Follows with us. Michele Follows is a professional executor, trustee, and attorney for property. She's a chartered professional accountant, a chartered accountant, and a CPA Illinois, as well as a certified executor advisor, or CEA. Michele's focus in the estate world started 8 years ago after the passing of her father. The experience made her realize that the lack of resources available to smaller estates and the number of unanswered questions that people often have. In response to this realization, Michele founded Executor Duties on Demand. She combined her 20 years of experience as a CA, specializing in accounting, financial stewardship for businesses, along with her personal executor experience and her focused skills to become an estate simplifier. Most recently, Michele has joined the Estate Stewards team as the Director of Estate Services, allowing her to offer affordable estate administration and estate accounting services to more people. At the end of her presentation, we will have time for a question and answer period. So if throughout the course of this presentation you have any questions, please type them in the chat and they'll be addressed at that point. Without further ado, I'm going to let Michele take it away.
Hi, and a warm welcome to everyone. Thank you for joining me on this webinar today. The topic today is, are you leaving a legacy or a landmine? Hi, my name is Michele Follows, and I'm an estate simplifier, and I hold people's hands through some of the darkest moments in their lives. When someone close to them has passed away, and they have to deal with all the personal items, the paperwork, the legal matters, the tax matters, and all that stuff that they have left behind. I'm a professional executor, trustee, and attorney for property, and I help to navigate the complex world of estates by either holding the executor's hand through the process or taking over for them. Before I begin, if it's okay with you, let me give you a little bit of history on me first and how I got about to writing this seminar. My focus on the estate world, as Shelby said, was started about 8 years ago when my dad had passed. And the two named executors were my dad's wife and my brother. And please understand that my dad's wife at the time was very distraught and emotionally incapacitated by his death. And my brother says to me, I don't have the time to do this, Michele. You're the CA. You do it. I said, sure, why not? How complicated can it be? I'm pretty good with numbers. So all I can say is, oh dear God, not only was there so much that should have been done before he had passed, but now what do I do? He lived his final years in Florida and had property up here in Canada, and there were so many other issues too. And I went looking for the answers on how to deal with all of these questions, but the estate was too small and the trust companies wouldn't help me. And the lawyer's fees were just a little bit out of my range. So now what? Where do I go? It was very clear to me that there was no one to hold the hand of executors through the smaller estates, and there was little resources available to them. So I completed the work and then thought to myself, how many other people need this help out there? So I bounced the idea of a tax partner that I know, and he was all for it. He said that he had lots of partners that needed my name, and because they're not allowed to act as executors, and they also lose the business to trust companies. So that was great. And so I said, I started my journey, and I was off to learn everything that there is to know about the estate world. And let me say, I'm still learning 5 years later. So I did my CEA designation, and I'm just completing up my CTIP designation, which is offered by the STEP Council, which is the Certificate of Estate and Trust Administration. And the experience that I've gained so much over the year that it became very clear to me that people don't know what they don't know. I started making a list of all the things that people should really know right now and how important it is to be aware and informed. And this list just kept growing and growing and turned into a seminar that I've titled, Are You Leaving a Legacy or Landmine? Because there's so many pitfalls that everyone needs to know and do now in order to avoid the various problems that they could run into if they don't have the awareness or they're not prepared ahead of time. So let's get started. I'm going to focus on 3 areas, legal, accounting, and estate matters. So first, legal. So may or may not know, there are 3 documents that people should have in place: a will, a power of attorney for property, and a power of attorney for personal care. The POA documents are used to look after someone's affairs while they're still alive, but they're not able to manage their own affairs. So there are 2 types of POA documents. There's one for property, and it's used to look after people's finances, so their assets and their liabilities during their lifetime, and the other one is for personal care. So this is to make lifestyle choices, social choices, and medical decisions for someone. And these power of attorney documents become null and void at the moment of death. And that's when the will document takes over. So the attorney for property does not have to be the same as the executor, but they are accountable to them. So they're essentially passing the baton of sorts. So the attorney for property will have to provide a detailed record of what happened and what they were looking after during that person's lifetime. So let me share some stats with you. Not only do 62% of people not have wills, but the stats say that another 12% have outdated wills that no longer reflect their current financial situation or wishes. So that's 74% in all. Wild. Wow. So why, you ask? Why are there so many reasons why people don't get their wills done? Well, let me go through some of them. Some people think that they're not rich enough and they don't have sufficient assets to warrant a plan. Some don't want to start a fight with their family. Well, if I choose Bobby, then Jeff will get mad. I'll just let them figure that out on their own when I'm gone. Some have the Superman syndrome. Oh, nothing will ever happen to me. Some believe that, well, fortunately, I don't need a will yet. And some do not want to think about death or incapacitation. It might just jinx them. And some keep on pushing it on down their to-do list, never quite making it a priority. I get it. Mine is anyway. And then people wait for the perfect time. I believe that they believe they should only be doing a writing will once, so they wait for that lifetime big event to happen, and then they write their will. Or maybe they believe it's too costly to write a will, especially to keep it updated regularly. I mean, from my experience, most wills are less than $1,000, so savings are way more than that. So, you know, I guess it's your own perspective on that, right? And the list goes on, and there's so many. Here's some more scary statistics. According to an article written by the Canadian Legal Will, even amongst the seniors over the age of 65, only about half of them have a valid will in place. And here's another crazy stat. It's actually the higher income earners and those groups that are most likely to not have a will. So I guess the cost really what the issue is here. Maybe busyness, I guess. But it's frightening to me that people just don't understand the impact of what it is to die without a will. So let's talk about that. What is the big deal if we die without a will? We die intestate, as they call it. So the problem of dying without a will is not so much is who's going to get my stuff and when, because all the things that you left behind. The problem is there's no one that has been appointed to look after that stuff. And so therefore the banks, the investment companies, the real estate people, everyone don't have the authority to talk to you. And so no one's going to talk to you or give you any information about what's happened with this person's estate. And you have to go and hire a lawyer and to apply to the courts to become this person's representative. So there's some costs involved in that, huge time delays involved in that, and meanwhile the estate just sits dormant because there's nothing that no one can do anything for this. So hopefully there's no urgent matters that need to happen. So now the state lawyer applies to the court, and this could take months, and a lot of confusion, right? So I'm just going to read an article by Sullivan Law. It's called Intestate, 10 Things That Happen to You When You Die Without a Will in Ontario. I could have probably reworded it and said it was mine, but I'm just going to read it for you because it's all the same stuff, right? So it says, 1, the law decides how the estate is distributed amongst your spouse, your parents, your children, and your siblings. So you have no say in the matter, right? Common law spouses do not automatically inherit your estate or even a portion of it. I'm going to talk about that one a bit later. I've got a blurb on that and how it's effective. It will cost additional time and money to get a personal representative appointed, and your closest relative will likely be the one appointed. Also, they might have to post a bond if you be allowed this role as representative. Personal items may not be distributed as you have liked, obviously, and some people may be left out. The dependent child or other relative may not be looked after. Number 6, someone else will decide who will become the guardians of your children. 7, you'll have no control over your funeral or burial arrangements. Number 8, if you have some charitable ideas and want to be benevolent, they will not be able to benefit from it. Number 9, possible increased tax and probate costs, and we'll get into that one later. Number 10, if you have no living next of kin, you get to give everything to the Ontario government. So let's talk about one other reason why people end up dying intestate, and that is that they do it inadvertently. They think that they have their wills in place, but their will is actually invalid. Here's an example. You have remarried. You're on to your second marriage, and you decided that each of your original wills that were in place before your marriage still works. As you were going to give your stuff to your children, and your spouse was going to give stuff to their respective families. Unfortunately, this will is not valid because the marriage contract will nullify any current wills that you may have in place. So they're now null and void, and technically you're dying without a will. So important to think about that when you get married and another one of your life events. So common law, another legal misconception I run across all the time, deals with the common law. The treatment of common law for tax purposes is very different than what the law says. So the CRA puts your incomes together and taxes you as a family unit fairly quick into the process. The legal law, if you want to call it, on the other hand, does not treat common law as family. So in a situation where you die without a will and you might have a common law spouse, this common law spouse will not be provided for under the Succession Law Reform Act. So they could be living with them for 10 years, you own the real estate, and they're going to end up with nothing, even if they've made contributions to that, if the real estate is the title is in your hands. So the law will split up your assets using a preset formula, kids and spouse and kids and parents, and this long hierarchy of who gets what, and the people that you really want to bless and look after might not be looked after. So you can see why it's really important to get a will, and also to know the rules and who knows what. You need to know what you don't know. So let's talk about probate. Probate is a process where the Ministry of Finance ratifies the current will. You see, because there's no will suppository in Ontario, and actually I just found out this morning that they have just launched a new will registry, but probate will still be in place. So they're moving forward, but not quite there. But the problem is that no one knows that the will that you're presenting to them is the final will and testament. So there's nothing that prevents a person from going to the bank and saying to the bank, here's the will, look, I'm the executor, give me the money. And so the bank goes ahead, gives them the money, and then someone a month later comes up and says, no, here's a more current will, I'm the executor, you have to give the money to me. And so the bank has no recourse except to go back to the first person and say, and ask very, very nicely, can you please return the funds to me because you're not the actual executor, I should have given the funds to this person. So what they've done is set up a process called probate, whereby the government, what they do is they ratify the will and they say, okay, this is the will that we are going to use, and they confirm to the banks and all the other people that require this probate document, third-party people in general, that we're going to use this will. We're going to say that this will is the valid one, and this is going to be the executor, and you can go buy it. So now we're telling the bank and the public and everyone that needs to use this will, this is the final will, you can go ahead and use it. And so most institutions, especially if it's over a certain dollar amount, I think it's $50,000 or probably less than that, they will not release any funds or give any information unless they have this probate document in place. And just recently, the authority for probate has been given to the Ministry of Finance to collect this probate tax. It used to be in the hands of the Attorney General up until I think January 2016 is when they switched it over. So you may or may not know, depending on what your background is, there used to be a provincial sales tax in Ontario. And so the government gave away with that quite a few number of years ago, but they kept on the people in the ministry, and they're now using the staff to audit the probate applications. So they've set up a new process also called the Estate Information Return, which is ultimately a breakdown of what the numbers are to support the numbers that you've put onto the probate application. And you have to follow this within 90 days of getting the actual probate document. So you don't have to get probate if the banks don't ask for it, if you don't need it. But if you have filed for probate and you do get the certificate of appointment of a state trustee with or without a will, you have to now have 90 days to file a detail of what was in that original probate document and send it to the government. And then the ministry has allowed themselves 4 years to audit these forms, regardless of the fact that you have, a proverbial executor year, which is usually about a year. And then you have, on the other hand, CRA's rules that enforce, the completion of a year much earlier than that if you want to take advantage of the charitable donation rules and all the other new rules that set up. So it's almost like the left hand is not talking to the right hand, right? I'm sure that most beneficiaries really don't want to wait the whole 4 years to get their inheritance. So the executors, you have to be aware of that, because the executors need to make sure that you keep proper records and that you save some of the distributions that would have gone to the beneficiaries right away. You need to hold them back in case you do get that audit. Or else you could have to pay the additional probate taxes personally. And understand that it's also the Ministry of Finance. So the onus is on the executor to prove that the numbers are right, rather than the Ministry of Finance to prove that you don't have the right numbers. So there's a little bit of an onus on there. So let's talk a bit more about these probate costs. Probate costs are really not that crazy. I mean, they're a lot less than the taxes that we pay. They're just 1.5% of the total estate value so they're really nothing to fear, but if you don't have to pay them, why pay them? So, but if you properly plan, we can bring down these probate costs down. So here's some examples. If you have an RSP, if you put on a designated beneficiary on the RSP bypasses the estate and goes straight to the beneficiary, and so you don't have to pay probate tax. That would be the same for TFSAs or insurance documents or any of that type of thing. So that's one way of bringing down probate costs. Or if you have a business or any business owners, if you get a second will and you put the business into that second will, you don't have to include it in the original will that you have to probate for, and then you don't have to get a formal valuation done, or you may not have to. You might have to. That takes a while to get a valuation done for the business, and it just saves time and money. So you need to look into getting, putting as much as you can into the second wills as you can to try and decrease probate costs. Let's see. Let's talk about joint bank accounts. It seems to be, this is the last thing I'm going to talk about on the legal side of things. It seems to be all the rage these days, setting up a joint bank account with your loved ones. And all I'm going to say is that, it could be beneficial in the circumstances, but any accountants or people that are tax savvy will know that there's tax implications of just changing ownership and title of something. There could be a capital gains involved in that process. And so you really need to look a little bit more than just going ahead and transferring an investment into a joint account. You also need to understand that the second that this person has legal title of that property, they can decide what they're going to do with it. So you might not have control anymore over that. So you want to be careful of that. And I mean, there's nightmare situations out there that you can read up on the internet of people that, have, decided they were going to, put something in their daughter's name or son's name, and then they've taken off with it. And, it's not exactly how they had intended it to be. And, you think they're doing it really to try and, avoid this whole probate tax thing. And really it doesn't, because the ministry says that if you have anyone that you have to put in the probate document, anything that you have beneficial ownership to. So if you put your name on, if your mom puts your name on your account, puts you on her account, her bank account, but the bank account really belongs to the mom, you're just doing that as, just to help out in case this happens. The government will put it on probate and make you pay probate taxes on it. So, okay, that's it for legal. Let's talk a little bit about accounting. As you know, it's important that proper tax planning should be done. We talked a little bit about the probate a few minutes ago. But let me give you a situation I ran into. It's sometimes easier to give an example rather than, going into the specifics. So here's a real life situation that I've done. I was called in to help as the executor. And when we took a look at the assets in the will, we noticed that all of the assets except the cottage bypassed the estate through these designated beneficiaries. So that was the RSP, the life insurance. And the only asset that was left in the will was the cottage. And that was supposed to be kept for the family cottage, and used by all 4 children and their families. But this was the last to die the spouse had already died. So she had, we'd have to pay taxes on this cottage. And there was no money in the estate to pay the $1 million capital gains that was in there, because everything has been sent out around that to try and bypass probate. So what do you do now? Like on death, because as you know, there's a deemed disposition, and her principal residency up until 2 years ago was her only house. So now she has the cottage, all those capital gains. So now what? Luckily, the 4 beneficiaries agreed, okay, we're just going to collaborate. We're going to put the money back into the estate to pay the taxes. But if any one of them decided that they didn't want to do that, they didn't have to do that. And luckily, they all get along, and I'm sure all of your families get along, but sometimes you have, some kids are not as cooperative as others. And, all of this was what? To try and bypass legal and probate fees. I mean, the disaster that could have, it could have happened is, incredible. So, in this estate also, one of those 4 beneficiaries was disabled. So, they had put in the RSP the designated beneficiary in trust for Bobby, right? But they didn't put any further instructions in terms of a trust deed or anything in the will that would help, like that would qualify as a trust deed to set up the Tenson Trust. And so therefore it wasn't enforceable. And so the money had to be given directly to this beneficiary, and it affected their ODSP benefits and all that stuff. Right? So another area that could have been, they've done the proper planning and knew about it ahead of time, we could have totally avoided that, right? And I'm working right now on one estate that has all of the bells and whistles. So the will was not properly executed. So there was missing pages, and there was one witness that was missing on the will. So there's extra work and legal costs involved to get that done. And luckily, there was not. We didn't have to go and test it. We could actually use that will. There was a foreign executor on there solely, and so we had to try and get the sister from Vancouver on board as the main executor, so that the state would not have to be taxed foreignly, and that no bond would have to be posted on it. And this gentleman did not file his taxes correctly, so now we had to apply for a voluntary disclosure to try and get all of his tax situation back in order. And he had several incorporated businesses, so the executors became the directors of those businesses. And of course, the taxes weren't done properly on those businesses either. So now we have the issue of dealing with that with the voluntary disclosure. And luckily, he didn't have any other business partners. The list goes on and on. He was also he hadn't finished being the executor of his mother's estate. So now the current executors become the successor executors for the grandmother's estate, and they have to deal with all those complications, and you have to try and value the grandmother's estate so you can put it onto his probate application, right? Because he inherits part of it. And the list goes on and on and on and on. So anyway, quite interesting. So because we don't have a lot of time today, I'm not going to get into detailed tax stuff. And to be honest, it's really not my area of expertise. I let the tax people deal with that. But I do want to talk a bit about the U.S. tax thing. So the people, let's bring it to your attention. If a person owns property in the U.S. that is valued at more than $60,000 U.S., there could be a state tax to pay. So people have this $5 million number in mind. Oh, it doesn't apply to me. But the threshold is actually $60,000 U.S. because you have to apply within 9 months for the U.S. exemptions to be qualified for the $5 million exemptions. And actually, it's less for us Canadians. I think it's $2.2 million that we're allowed to do. So if you don't apply for this exemption, you now have a U.S. estate tax implication that you have to deal with. So you got to make sure that the executors don't delay, and sometimes you don't even thinking about the situation when your 9 months is already passed, right? And then I want to talk a bit about on the power of attorney side, that you need a separate power of attorney document from the U.S. state that you might have the property in, because the U.S. authorities will not acknowledge a Canadian power of attorney document. So you've got a you've got a condo in Florida, and your POA in Canada is in charge of technically it. But if you don't have a POA document in Florida, you're not going anywhere. You're not going to be, the attorney up here is not going to be able to deal with it. So here's some other issues, like these are just things you need to think about, before you, I guess, like I said, things you need to know now, right? And you might not be aware of, right? Okay, so my favorite topic, let's get into estate stuff. Let's get into my world. So we talked about earlier an estate trustee, which used to be called an executor. So there's two names for it. Actually, the new name is estate trustee. They've been given the fiduciary responsibility of managing someone else's affairs after they've passed, and they're expected to handle all of the assets and liabilities with due care and in a responsible manner. So every executor must successfully navigate this complex world, regardless of their education or personal background. So the duties that are performed by the executor are regulated by law under the Succession Law Reform Act. And these are specific rules that outline what an executor can and cannot do. It outlines investments that they're allowed to invest in or how much compensation that they can take. And every executor is expected to abide by these rules and must be, regardless of their education or personal background or experience, and whether or not they even know that these rules exist. These are the rules you need to live by them. But the overall responsibility of the estate remains with the executor. So they're responsible for overseeing the estate proceeds and making all the final decisions. Even if they decide to hire some professionals, which we'll talk about a bit later, and they don't have to do the work themselves. They just have to make sure that the work gets done properly. So let's answer specific questions. What is the risk that I'm taking accepting the role of being executor? And am I personally liable? So the law says that if it is determined that certain losses to the estate, such as late filing penalties or the sale of assets below fair market value, much less than what they could have gotten for it, and if it could have been prevented, the executor could be accused of fraud or negligence. So in addition to having to repay any compensation that they may have taken as an executor, they could have to use their own personal funds to compensate for their actions. And if the executor happens to prematurely distribute the estate, and there remains any liabilities or taxes in the estate, they could have to be personally compensate these creditors or other beneficiaries for this misjudgment. So it's important to understand what your liabilities are. So question number 2, when does the executor's responsibilities actually begin? So executors, as we said, are legally appointed by the will. So their responsibilities begin, if there's a will in place, they begin at the moment that the person is deceased. And because many people are confused, well, what about this whole probate application and all that stuff? So the will says, Bobby is the executor. That gives him the authority to do what he needs to do. So the executor does not need to wait for probate to assume his or her responsibilities. And in some cases, you don't need probate. But the probate just ratifies the fact that there is the executor in the final will to any third party that might need it. So executor's responsibilities begin immediately on death if there's a will, and if on court decisions if you don't have a will, right? So question number 3, what if I don't want to act as executor? So let's say you've been appointed as an executor and you don't want the responsibility. You just don't have the time, or you didn't even know about it, and you're just not in a good place to do it right now, or for health reasons, family responsibilities, the like. So you're fully entitled to rescind and not act as executor. But you must, however, decide this at the very beginning and not get involved in the estate matters in any way, shape, or form. So you have to be careful not to start, or what they call intermeddle, as they call it, because actions speak louder than words. So you can't simply just start the role of the executor and go, oh, I don't have the time anymore. I'm just not going to do it. I'm going to, and try to appoint someone else to be the executor. It doesn't work. You would have to apply to the courts and actually ask them to be removed as executor. And if you don't do this, and the courts can actually say, no, you have to stay on as executor. But if you don't do this and the affairs of the estate go astray, you, as I said above, you are personally liable for what's going on. So you have to be really careful. If you don't want to be the executor, make sure you know that right in the beginning and don't get involved at all. So can I get assistance or subcontract out my duties? Is question number 4. So it is important that an executor use whatever resources that they need to ensure that the affair of the estate is handled properly. As such, the executor can seek assistance in all areas, including services of the tax preparer, an estate lawyer for probate or other needs, sell the real estate, an investment lawyer investment advisor, and a professional executor such as myself or a trust company. There's some free resources available online as well. There's some checklists and other information. And you might see that many funeral homes also offer an aftercare program that helps with some of the initial paperwork. But be careful, because this initial paperwork, people think, oh, the funerals have done it all for me. They do maybe 3% of what really needs to get done. And so you need to take a look at what the full role entitles and all the duties that you have to do. It just kind of starts you in the right direction, but it's not all inclusive. So remember that you've been personally chosen by this to be the best person possible to administer the estate when someone has gone. They trust you. But your job is to make sure that the estate is properly administered, not necessarily to do it all themselves. So question number 5. How can I mitigate the risk liability of being an estate's trustee or executor? You do have full responsibility ownership, and you can get professional assistance as you need. But there's also the executor insurance. There's a company called Erasure out there that offers executor insurance at a reasonable price. And so there's some risk and liability that can be avoided. So question number 7, what happens if the estate is actually insolvent or bankrupt? So if the estate is insolvent or bankrupt, the executor should seek legal counsel immediately. If the estate is handled properly, the executor doesn't become personally responsible to cover the estate's liabilities. It goes to a bankruptcy trustee, and they look after that. So it's not that the executor becomes personally liable, but you have to make sure that you take the proper precautions at the beginning. Let's look back at that case above that we talked about where there was no money in the estate to pay the taxes. The estate was not actually insolvent because it was a cottage. So that means that the cottage would have had to be sold, and it wouldn't have been handled the way that you wanted to. Even if the estate everything bypasses the estate, so let's say RSPs go to these designated beneficiaries, you may or may not know that the RSPs get taxed in the estate. So you could have a tax liability in there and no assets. So the CRA will actually go straight to those designated beneficiaries to grab the money. So, there's things that you need to be aware of if there's just not enough money, and you need to handle the affairs properly. So, question number 7, compensation. So compensation, as you may or may not know, is allowed by the Succession Law Reform Act, and is valued at 5% of the value of the estate. So it's 2.5% of the value of the assets going into the estate and 2.5% of the value of assets going out of the estate. And the reason they split it up is because you might have a capital gain on a real estate. So people wanted to make sure that they got the full value of that, right? So it's a bit more tricky if you, in terms of compensation, if you're a professional, because let's say you would offer one of these services such as an accountant or a lawyer or an investor. Your work needs to be split between your professional business and actually what's an executor or what belongs to the executor or estate work that should have been done. Because the funds come out of 2 separate pools. So the 5% relates only to the executor work. It doesn't relate to the, if you're doing legal work or investment work on the side. But you have to be really careful because there's special rules regarding these professionals and what you're allowed and what are not allowed to charge because they don't want people to double dip. So the Succession Law Reform Acts will say, like, if you are an investor, you can't get compensation for, the financial planner and get executor work for the same thing, because they don't want conflict of interest or any of that stuff. So you have to be really aware of what you can and cannot do. Also, because there's such a thing called pre-taking in the will. So a pre-taking is a special term that says that you're allowed to take your compensation ahead of time. If there's no pre-taking written into the will, then the executor has to wait until the estate is distributed to get paid the executor fee. So, and as you know, some of these estates can take 2 or 3 years to settle. So that would mean that your fees as executor would get delayed until that process is done, because they need to be signed off by the beneficiaries as part of the estate distribution process, right? And please remember that executor fees are considered income and appropriate tax, like to everyone who's taking them, and appropriate taxes must be paid at all levels. So that means GST and there's personal taxes that need to be done, or business taxes, whatever. Depending if you're a professional executor or not. So let's summarize. Be smart, be honest, be responsible, and get professional help if you need to. And you will safely execute your duties with minimal risk and exposure. My slogan is be aware and be informed. So we talked about some of the pitfalls that you need to be aware of, and it's important to know what you need to know. And be informed. I tell people it's way too costly not to hire a professional. Because it costs the estate the exact same amount, that 5%, whether you hire your cousin or a professional executor to do it. So the landscape is forever changing in the estate world, and the rules are always changing, but the executor still has the responsibility to be informed and prepared. So it's important to have a strong team of professionals around you that will ensure that your tax, your investing, your insurance, your estate needs are all addressed, regardless of where you are in life and whether you have enough money to worry or not about it. And I would be happy to be part of your estate team. So let me summarize it this way. A landmine can be described with the acronym CHAOS. So C is for costly, H is for haphazard, A is for ad hoc, O is for obstructed, and S is for stressful. So CHAOS, if you're, is a landmine. And on the other hand, you can leave a legacy. The acronym is order. So you'd be organized, restful, decisive, efficient, and ready. So I thank you for joining me today in this seminar. In this seminar, Are You Leaving a Legacy or Landmine? This seminar is actually designed to be much longer, and so I've cut out a lot. It's designed to be a lunch and learn, whereby professionals such as lawyers or accountants can invite their clients. And what we do is we present, and whatever field that this professional is their strength, and they want to present to their clients, I'll give them speaking points to it, and then we'll come up and be the rest of your team. So if you're an accountant, for example, I will tell you what the tax matters, and there's a lot more actually, and accounting pitfalls might be, and then we'll bring in a state lawyer along and myself, and we can just look very incongruent as your team to your client. So as a follow-up to this webinar, I want to reach out to each and every one of you and see how we can collaborate to bring the maximum benefit to your clients and their families who might have executors or be executors or know of executors. And I want to outline that we do offer a referral fee and to compensate you for your time and effort. So let me help simplify the role of executor for you and your clients and increase the value added to your client relationship. Also, we're about to launch the Bobby Project, which is a movement to try and get 1,000 people to get their wills done. We'll reach out to you where people can sign up if they've gotten their wills already done, or we can direct them as to how they can get their wills done in the process. And if it's helpful to you, I've also written a blog on how to write a holographic will. It's a holographic will is a handwritten will, and you can have that done today. There's no, you have to have it in pen and ink, and you have to have, you have to sign the bottom of it. You don't have to have any witnesses for it. So it would be an interim measure, and there's no cost. But let's at least get something done today until you can get a formal will done. Thank you, and thanks for spending a couple hours with us.
Thank you very much, Michelle, for that presentation. It was very informative. We do have a couple questions just to end off, and if anybody else has any questions, feel free to type them into the chat now. So, number one, what's the difference between the power of attorneys at the bank and the ones that you would prepare with a lawyer?
So the power of attorney, the banks will ask you to fill out their specific power of attorney form, so that it has all of their legalese stuff in it, and that's good, and that type of thing. And the power of attorney at the bank is only good for the one at the bank. So you have to be really careful because the power of attorney at the bank will override any power of attorney document that you might have. So because it's always the one that's the most current date document. So you got to be careful not to sign the one at the bank. So you want to have your power of attorney document for property in place. You want it to be a continuing power of attorney document, and then you'll take that document and go present it to the bank and say, "This is what we're using, and I'm not going to sign one."
Great. And just another question: what are living wills?
So yeah, there's a lot of hype out there about living will, and it's not actually a formal will. Living will is a document that goes with your power of attorney for personal care, and it's really someone's wishes. Because the personal care one talks about medical. So do you want to be resuscitated or not? There's some people that want, that if they get into such a certain state, they want euphemism. I'm sorry, I'm brushing up the word. But it talks about, if I usually give Christmas gifts to my kids of $100 each, that type of thing, or I want to live in a nursing home, or I want to live at home, or give guidance to the person that's looking after them as to if they had a choice, what would their wishes be? But really helps them to live in a method that they choose, not necessarily what the power of attorney would choose, because that's what they think is best.
Just a couple more questions here. You mentioned that you have to know right away if you don't want to participate as an executor. Can we hire you if we are partway through and can't stand the process?
Yeah, actually, I work as an agent, so that's exactly what I do. Is I will go in. So you cannot give up your executor role, but I can do all the legwork for you. And so all that means is you still have full responsibility to make sure it's done. But I will go through and say, okay, I will help sell the real estate, or I will look after get these get your car looked after. Or I will set these items up for auction, or all the items on this list. My list has got like 650 different things on it. We'll start to pinpoint exactly. And so then we go through and I'm going to do this and you're going to do this and get everything done. And we do charge by the hour, so it makes it more efficient. So it's like I will do these 10 tasks for you, and then you're still in charge, and so you still have responsibility, but I make it easier for you and hold your hands through the process.
Just one more question. So when do you get involved in the estate process?
Well, I can get involved at any point in time. Like we just talked about, if you're an executor and you realize right away, or if you're further on and you've seen specific things, that you're not comfortable with, that I can help out with. Sometimes getting the probate documents in place. Sometimes it's talking to the beneficiaries or helping out with certain family matters. This family cottage, we had to get a document in place as to how the 4 kids would agreement as to how the 4 kids were going to live in the cottage together, right? Or I can get written in someone's will. I can get written right away, and so then when on the person's death, I will take over as executor. So whatever is needed.
Excellent. So thank you very much, Michele. If there's no other questions, then that will bring us to the end of today's webinar. Thanks so much to everybody who's joined us. We will be sending out PD certificates to those who are online and who have listened live. And we will keep you informed on future webinars. This is being recorded, so in the next couple of days, look out on your email and you'll be sent a recording of this webinar, as well as some of the supplementary materials that Michele has spoken about. Thanks very much, Michele, for your time. We really appreciate having you here. And we hope that everybody listening has a great day.
Thank you.
Thanks.